Hello and welcome to COVID-19 Law and Policy Briefing. I'm Leo Beletsky. I'll be moderating today. I'm a professor of law and health sciences at Northeastern University in Boston and UCSD Law School in La Jolla. Today we'll be talking about protecting vulnerable substance use disorder populations during COVID-19. This is a topic that's close and dear to my heart as someone who researches the intersection of infectious disease and substance use disorder. We're really lucky today to be joined by two prominent lawyers in this area. First, Deborah Reid, who is a senior health policy attorney at the Legal Action Center in New York, and Nick Terry, who's a professor and executive director of the Center for Law and Health at Indiana University, Robert McKinney School of Law. So welcome to you both. So the topic for today is kind of focuses on exceptionalism for substance use disorder treatment. So this is kind of a very strange area of law that I'm hoping that, Deborah, you can talk a little bit about where things were before the pandemic hit when it comes to substance use disorder treatment and how the law addresses that particular area of healthcare.
Sure. And first of all, thank you for having me. Prior to the pandemic, a few things were going on that were in our national landscape. One thing in particular, substance use disorder patients were really concerned about any changes or efforts on a legislative or regulatory basis to weaken existing privacy safeguards of disclosures of their healthcare records. And the reason why they were very concerned or remain concerned is because substance use disorder is not like any other chronic disease. People can get arrested for using an illegal substance, unlike if you have cancer or some other illness. People have lost children. People have lost employment. They've lost public housing benefits because disclosures of the fact they are in treatment have gotten out without authorization. So it sort of sets substance use disorder apart from any other illness. So that concern about weakening privacy rights was out there. Secondly, the other issue that's still out there is some insurers in states were not providing equitable coverage of substance use disorder and mental health services versus any other type of coverage of healthcare services. They weren't, in some states, were not enforcing their mental health parity laws that provided that equal coverage of services. Also, that was prior to COVID-19, we had incarcerated people not getting adequate access to mental health and substance use disorder services upon their release and out into their communities due to a number of factors, one of which was lack of health insurance like Medicaid, and also the lack of adequate providers in their communities that take those services. And lastly, I mean, we could go on, but lastly, in general, people living with substance use disorders and mental health illnesses weren't getting adequate treatment because there's still existing stigma, there's still existing a focus on incarceration instead of treatment. So this is what we're living with prior to COVID-19.
Thank you for that very thorough overview. And Nick, can you drill down just for a second, specifically addressing the laws and regulations for opioid agonist therapy and why that was especially important in the context of the ongoing overdose crisis?
Right. Well, I mean, historically, as you point out, we've had exceptionalism in this area, and some you may view as positive exceptionalism with regard to Part 2. But other aspects, really, the exceptionalism seems to... The privacy rules, the substance use privacy rules. It's 42 CFR Part 2, sorry, technique. But clearly we have seen quite distinct access to drugs and other services for those with substance use disorder compared to those with other chronic diseases. This was sort of partly historical, and then the Controlled Substances Act, criminalization, fears of diversion sort of piled on top with specific controls designed at MOUD, medicines for opioid use disorder. These have included particularly robust regulation of the prescribing and dispensing of methadone and buprenorphine, which I always get wrong. As the former, methadone, before the crisis, before the pandemic, is only dispensed through a SAMHSA-certified opioid treatment program that also provides that patients have to receive counseling, not just the medication. And one of the problems, as you all know, is that we have a relatively small number of these OTPs. In contrast, buprenorphine can be prescribed or dispensed in physician offices, but here too there's a kicker in that the physician or other clinician must apply for and receive a waiver to so prescribe. The clinicians who can be waived, the number of patients they can treat, have slowly been liberalized, but this is still a considerable burden because only about 7% of clinicians have received this waiver. So these are access problems that pile on top of the ones that Deborah just talked about.
In other words, there exists essentially kind of a separate, unequal system of care for opioid use disorder specifically, and that system is both programmatic in the sense that you need to go to a clinic to get methadone, and you need to go to a specifically waivered physician or another prescriber to get buprenorphine. And just to kind of finish that discussion, why are those two medications in particular important in the context of the overdose crisis?
Generally, I believe the view is because of the likelihood of diversion, whether evidence-based or not.
Right, but Deborah, did you want to comment on why those two medications are have been just so closely watched and so closely discussed in the context of the overdose crisis?
Well, I just wanted to add that those are two of the medications that are really part of the arsenal of medications that are FDA approved that are needed to address this opioid crisis. People have different illnesses that respond to different types of medications. So we certainly need what's in the scope of what's FDA approved to address that, and those medications are.
Right. No, absolutely. And the statistic that often gets cited is that methadone and buprenorphine treatment, maintenance specifically, not so much sort of detox. People often talk about detox or rehab, but the maintenance on those medications cuts overdose risk by 50 to 80%. So in many ways, that arsenal, Deborah, that you talked about is either central to our overdose crisis response. So now shifting gears to our new reality as of 4 to 6 weeks ago. So we have this ongoing overdose crisis, and in comes this pandemic. So in many ways, the stage is set with not just one, but kind of a pandemic coming into an existing public health emergency. So it's in some ways it's kind of a syndemic where two or more problems are coming together to sort of do more damage than they can on their own. So in the context of the pandemic, what are the issues and sort of the legal changes that have come to pass since this new reality set in? Deborah, do you want to talk about specifically the CARES Act provision?
Yeah, but before I do, I just want to say that this pandemic has sort of served as a magnifying glass as to our existing health inequities in our society. I'm definitely in the Dr. Anthony Fauci camp when he said that this shows what those systems that are in our society that aren't working. That shows those health disparities, those health inequalities for communities of color and low-income populations. We have seen all of that happening. We've seen a disproportionate number of Black and brown people dying from this disease, and there's been efforts to call for more testing and treatment and data collection of that for these communities. But that's what's going on. These communities, as you know, are disproportionately impacted by other chronic health diseases, which makes us more vulnerable. And just another thing, we have a number of people who are working in those frontline positions who don't have the luxury of working, doing telecommuting. There are cashiers, there are delivery people, there are, of course, our healthcare providers. So we see how there's some vulnerable people in our society based on this pandemic. We also see how what has happened because there's been a lack of the Medicaid expansion in all states. Those states that did not take advantage of that Medicaid expansion of eligibility, you have now a large population who are potentially impacted by this disease who don't have health insurance, who could have had health insurance, which leads to more deaths and illnesses. So that's what we're sort of sitting on right now. In terms of the CARES Act and confidentiality and privacy protections, basically the privacy protections that deal with substance use disorder were just attached to the CARES Act. The CARES Act was just a vehicle. If you look at the privacy protections that are in the CARES Act, you won't see any mention of COVID-19. So the CARES Act was a vehicle for those provisions to move. But nevertheless, they moved because the CARES Act was passed. And there are a number of things that the new law does, which incidentally is not effective until a year after enactment, which means March 2021 is when those provisions become effective. Just quickly, what's in the CARES Act as it relates to substance use disorder and privacy, it maintains the current requirement for consent of disclosures of substance use disorder treatment records for treatment, payment, and healthcare operations purposes, which is a great thing. Patients can take back their consent if they change their mind. They can revoke it for future uses or disclosures of their substance use disorder records. But there's some caveats in there because we're using a HIPAA standard and HIPAA definition of treatment, payment, and healthcare operations purposes. One, the CARES Act will allow redisclosures of substance use disorder information for payment purposes, and that can lead to discriminatory denials of insurance, like life insurance for certain people. That has happened before. In New York, there was a situation with some nurses who were denied life insurance because they were trying to get prescriptions for their patients, substance use disorder medications. And also, the treatment portion of those disclosures, those disclosures for treatment purpose are not limited to providers that the patient may know. Under our current regulations, under 42 CFR Part 2, the patient has an option of disclosing their records to all of their treating providers, meaning people who they know, who've agreed to treat them. Unfortunately, there still are some providers who treat substance use disorder patients badly, who deny care to them, who give them, care that's substandard. So this new law just gives it a more broader spread in terms of treatment. And then we come to the healthcare operations portion, treatment, payment, healthcare operations. The healthcare operations standards for disclosures, it also includes, under a HIPAA definition, disclosures to non-patient care functions, things like underwriting, fundraising for a particular healthcare entity, training of non-legal staff, legal services, sales and transfers of assets. Now, why is that important? Because all of those functions that are non-patient related are potential avenues for people's information to be disclosed for reasons not for treating purposes, but for other reasons like everybody doesn't live in a big city. People live in small towns. You know, the person that's working on underwriting may be your next door neighbor, and all of a sudden they know that you are in treatment, and you may not have wanted them to know that. So that's one of the issues that remains with the CARES Act. Although the CARES Act includes some anti-discrimination provisions, which are great, the problem becomes that these anti-discrimination provisions do not cover discrimination against people who are using illegal substances. And why that is so, because our current anti-discrimination provisions like the Americans with Disabilities Act and the Fair Housing Act have an exception for protection for people who are currently using illegal substances. So people who are using heroin, cocaine, and in some states marijuana, which is still illegal in some areas, will not be protected by those protections in the CARES Act. And finally, there just needs to be more guidance and training from SAMHSA on the changes in this particular law. I mean, for all stakeholders, including providers, families, patients, of course, everybody in the health field, insurers, etc., so that people understand what their privacy, confidentiality requirements are, and rights as well. And that should be done in a way that's done in a culturally competent way, also done in a way that people who have limited English proficiency will be able to understand what those requirements and rights are, and people who have limited health knowledge will understand as well.
Thank you. That's really enlightening. So we'll come back with some questions, but before we do that, Nick, I was wondering if you could talk about the actual service provision regulations and how that has responded to COVID-19 and why that may be important.
Actually, I think it's been a sort of a rather pleasant surprise that SAMHSA and the DEA have sort of got out ahead of this. We were expecting the usual HIPAA emergency declaration stuff and so on, but DEA really came out of the blocks fast. So, for example, now you can, there's an exception so that medications can be delivered by persons other than licensed clinicians and through indirect means such as doorstep lock boxes. You can have longer prescriptions. They vary depending upon the stability of the patient, but this means longer supplies. The DEA has also liberalized the prescription of buprenorphine, primarily by increasing the use of telehealth, which included waiving the requirement.
Why is that important in the context of COVID-19?
Because people can't get out. People are locked in. People with these kinds of disorders are in worse shape than those of us in better health. They are in their homes stuck without the drugs that keep them in one piece. And so being able to get these drugs supplied to them is so important. With regard to buprenorphine, there is now much increased use of telehealth. There's been a waiver of the requirement there first be an in-person medical evaluation. This then, even days later, this was further liberalized, allowing telephone prescribing without any examination. And we're hearing stories, really upbeat stories of clinicians going through the homeless populations with their cell phones and be able to get treatment directly to persons with so much less friction. Now, new methadone patients still have to have an OTP initial screen, but generally we're seeing quite a lot of liberalization. There's also liberalization with regard to telehealth reimbursement for Medicare, which is a subset here, and some states are liberalizing reimbursement for Medicaid telehealth.
On the privacy issue, Deborah, of course, is quite correct in a couple of ways. First of all, this had nothing to do with COVID-19. It just appeared without much notice in the COVID-19 bill. Secondly, as she points out, it doesn't come in these regulations, won't kick in for quite a long time. And the difficulty of writing these regulations that we've seen before, we may not see them for 2, 3, 4 years. The overall policy question, of course, is, do we want to separate privacy regimes? The answer endorsed by SAMHSA and many of us has always been yes, because of all the issues that Deborah raises. On the other hand, we know that this has caused major problems for providers, providing continuity of care, for how they record in the EHRs and so on. So this is an attempted recalibration of that. We don't know how good or how bad it is yet, I think. But as Deborah notes, the anti-discrimination provisions are really interesting. There are gaps in them. I certainly see. But for the first time, we really do have anti-discrimination laws passed directly to address this issue, which was the major objection to changing the privacy law in the first place. So we'll see how those play out also in the regulations. The other part of CFR Part 2, 46 CFR Part 2, has been historically the protection of substance use records during the courts process, testimony, and so on. Those provisions remain the same and, in fact, have been slightly strengthened. So I think there was an attempt to sort of try and balance this during this recalibration. I don't think we'll know whether the extent to which Deborah's fears play out until we see the regulations.
Thank you. And just to, we're coming to the end of our broadcast, and one of the questions that I try to ask of all participants is to comment on, sort of, there's been a lot of change that has been brought by this pandemic, and some of it good and some of it not so good in terms of the legal frameworks, specifically with substance use disorder as well. And we all want to, return to some semblance of normalcy, but in some areas, the normal default wasn't that great to start with. And so I wanted to ask you both, starting with Deborah, about, when this is all over, what changes would you like to see maintained, and what changes would you like to see sort of return back to normal, or to the default that existed before?
Well, I think one thing that has occurred, which is a positive thing, is that we've seen the healthcare delivery systems be more creative because of this crisis. People back in the day said, we can't possibly do telehealth for behavioral health services, for mental health and substance use disorder. That just wouldn't work. Now we see that is working. So this is a good thing. I'm sorry it had to come because of a crisis, a healthcare crisis, but that's a good thing that we have seen that it's working, and works well for people, not only in substance use disorder and mental health, but in other services as well. I would like to see, when we air quote return back to normal, that we do better. We do better for those populations that are underserved. We do better for making sure we have adequate resources for our first responders that are out there. We do better for that we get Medicaid coverage for low-income communities, for all low-income communities across the nation, because if we don't, we see how populations will remain vulnerable and will remain sicker and will die because we're not doing better. So I also would just like to see that we understand the importance of privacy for patients who are substance use disorder patients, and also patients who have other sensitive health conditions. There's still state laws that have confidentiality protections for certain healthcare information, HIV and AIDS, mental health, genetic testing. I can go on and on, but privacy is still very important. Yes, we need to coordinate care, but we don't need to do it at the expense of people being too afraid to come in for treatment.
I say amen to that. Nick?
Well, I think, we are watching a sort of natural experiment here, aren't we? We will find out maybe a little bit more about what it means to stop having so many soft arrests, and particularly with regard to drug paraphernalia and so on. What will it mean if we stop using our jails and prisons to warehouse the old, the mentally ill, those with substance use disorder? Why did the first call as soon as this happened was, will we have out-of-pocket payments to have COVID-19 testing or treatment? Well, that tells you something about the problem of out-of-pocket expenditures that everybody is facing. And then I think in the specific areas we've been talking about today, DEA is going to have to watch to see whether it really can shift from exceptionalism to sort of universalism. Maybe this recalibration of how persons access their MOUD might really be worth what is likely to be some abuse, likely to be some diversion, but maybe we can see a route forward to calibration that shifts so that more people get more treatment faster and better.
And with that, we're going to wrap up. I think in many ways, COVID-19 has shown the light, as Deborah was saying, and Nick as well, on things that were really not working very well. And substance use treatment is one of those areas. And the crisis provides an opportunity to, from chaos comes order in a little bit to try to experiment and create a new, better way of doing things than we were doing them before. So this has been COVID-19 law and policy briefing focused on substance use disorder changes. And I'm sure this is just the first of many conversations on this topic. And I wanted to thank our presenters, Deborah Reid, who is a senior health policy attorney with the Legal Action Center, which, by the way, does amazing work on this in this area and it has for years. So you should check them out, Legal Action Center in New York. And Nick Terry, professor and executive director of the Center for Law and Health at Indiana University, Robert McKinney School of Law. And Nick has been doing really groundbreaking work on the overdose crisis in the sort of Midwest area, and has done a lot of legislative advocacy and testimony, and I thank you both for joining us today. And thank you so much also to Dave Halleck, who's our producer and is responsible for making all of this work behind the scenes. Thank you so much.
Thank you.